At this point, in the context of a motion for a new trial based on the insufficiency of the evidence, Your Honor is also entitled to take into account not just the state's case, but the defense case as well. And we would submit, when you put all of that together, Your Honor, there is not a basis in this record to find that the state, given all the benefit of its reasonable testimony, reasonable inferences, that the state proved this case beyond a reasonable doubt. There was, as Your Honor knows, no physical evidence linking Ms. Lodzinski to the death of her son, not in her house, not in her car, both of which were searched multiple times. 2 medical examiners independently reviewed the case and were unable to determine a cause of death. Both of those medical examiners found no evidence of injury or trauma to the remains of Timmy Wiltsey. There was no history of abuse or indications of any abuse observed by any family members, by Timmy's teachers, by the school nurse, none whatsoever.
The juries heard his theory, heard his defense, and they rejected it. I don't want to relitigate this case. We're not here to retry this case again, Judge, but the facts were basically clear, and for purposes of the record, Ms. Lodzinski was the last person seen with the victim alive. Nobody came forward that knew him, ever saw him at the carnival. He was found dead in a creek, a normal, healthy 5-year-old boy with no history of illness, no disease, nothing that would cause his death. Found in a swamp basically across the street from where she used to work. When evidence putting his sneaker in the area was found, she never mentioned that she ever worked there. In fact, she took steps to conceal the fact that she ever worked there. And then the remains are found, Judge, almost a year later, 11 months later. There could be no finding of trauma. There was only a few bones left, but thankfully those bones were able to identify the victim as Timothy Wiltsey.